Hi everyone, I'm Mike. So a bit of a gear change from generative AI. I know Mark has promised you some chat about fines, so we will be talking about that. But more particularly, I'm going to talk about some of the drama going on in the GDPR's one-stop shop. So as a quick reminder, part of the European Data Protection Board's role is to issue binding decisions under Article 65's dispute resolution mechanism. This happens where concerned data protection authorities, DPAs, raise objections to a lead authority's draft decision which is given against an organisation, and where the DPAs can't reach a consensus. So of the 8 that the EDPB has published since it was formed, 6 of those were issued in the past 12 months. So it has definitely been getting busier. Let's run through a summary. In these decisions, you can probably notice there's a bit of a trend on the companies and the authorities. So we've seen several interesting disagreements between DPAs. We've seen issues of scope creep, and we've seen significant increases in the fine amount following the EDPB's cooperation and consistency process. So one example, we have cases where the lead authority has carried out a multi-year investigation into an organisation. Then after that investigation, it's issued its draft decision to the concerned data protection authorities, and actually only received objections from a small minority of those DPAs. But despite having a minority of objections initially, the process suddenly spirals, and then we end up with a majority of DPAs voting for additional brand new GDPR infringement and a substantial increase, sometimes a 5-fold increase, sometimes bigger, as happened on Monday, that comes out at the end. So Monday, I'm sure all of you will have read, was the largest GDPR fine ever issued. This was the Irish DPC's decision against Meta Ireland in relation to data transfers to the US. But I mean, one thing that was very interesting is the draft DPC's decision just contained one order, which was the stop transfer order. But it was the EDPB process, following objections from just 4 countries, France, Germany, Austria, and Spain, if you're interested, which then led to another 2 orders, so the compliance order, and also actually going to a fine of 1.2 billion, up from 0, which the DPC proposed in its original draft. So cases like this one show the significance of an EDPB decision on organisations, obviously, and it highlights the importance of there being a clear and an effective legal route to challenge such decisions, which leads us to the next issue. How do you challenge an EDPB decision? Well, in December, the EU's General Court dismissed WhatsApp Ireland's appeal relating to the second decision up there, and because they said it was inadmissible. It couldn't be appealed directly to the EU court. So for their reasoning, they said that the EDPB's binding decision to WhatsApp, or in relation to WhatsApp, was addressed to the DPC, the lead authority. It wasn't addressed to WhatsApp, so WhatsApp couldn't directly appeal it. Even though the GDPR itself does expressly state that this should be a possible appeal process, which was interesting. So the obvious problem here is that the primary addressee of an EDPB binding decision in this context is going to be the lead authority that issues the fine, and it's probably wishful thinking that the lead authority that's just fined you is then going to appeal it to the EDPB themselves. So what appeal route is left for organisations? Well, they can, of course, appeal the lead authority's decision to the national courts. So in this case, that would be to the Irish High Court. But the national court doesn't have the power to question the validity of the EDPB decision that has had such a big impact. So the company still has to push the National Court to refer questions up to the EU Court of Justice in order to hopefully get a preliminary ruling back down and can continue in the National Court. That seems to be what the General Court is saying is the only way to challenge a decision. That is going to be an interesting proceeding, though, when the lead authority has just publicly said it already disagrees with the EDPB decision, and yet it's the one that has to be appealed. So we shall see. I think this raises some important questions about core principles of justice and to the right of organisations to have a fair trial. It takes away the right of direct appeal on the left. Even though EDPB binding decisions obviously can have a substantial impact on them. So it's worth mentioning that WhatsApp is, as you might expect, appealing both the decision that is inadmissible in the General Court, and they're doing parallel proceedings in the Irish High Court. So I guess we can all just see what happens next. Now, before I hand over, I couldn't finish up without mentioning just one other bit of drama going on, which is between the Irish DPC and the EDPB. This was in January. The Irish DPC threatened to itself apply to annul binding decisions issued to it by the EDPB. And this happened because in 3 different binding decisions, the EDPB said you need to start brand new, quite wide sweeping investigations into all of Facebook services and Instagram services and WhatsApp services, including looking at special categories of data being processed. And the DPC said, no, we think this is a potential overreach of your remit, EDPB, and they have now, the court records show they've applied, made their applications for annulment. So in a nutshell, everyone is arguing with everybody, and I think it's safe to predict that there'll be more theatre on this to come. Thanks very much for listening, and I'll now pass you over to Anna, who will talk about the US Data Privacy Framework.